This is Barry Zalma on insurance. This is part 4 of a video explaining how to deal with catastrophes like the polar vortex. In this part 4, we speak about more about the presentation of a claim, and sometimes that there will be a need to seek proper legal advice. In that regard, as an insured, never sign a release, a waiver, indemnity, a hold harmless agreement, or an assignment of benefits to a contractor or any other third party without proper legal advice. If the insurer, adjuster, consultant, or contractors ask you to sign a release, waiver, indemnity, or hold harmless agreement, ask them to explain why, and to explain why in writing. These kinds of agreements can be used to deprive an insured of rights and benefits and may obligate you to pay thousands of extra dollars for issues that arise. Consulting a policyholder attorney to determine your rights before signing such an agreement is prudent and exceptionally wise. Similarly, if a public adjuster or contractor asks you to assign the monies to be paid by your insurer to the contractor or public adjuster, you may be giving away your right to receive the money from your insurer. Always get proper legal advice from a competent attorney before signing any such document, and make certain that your insurer is told that any payment made to a contractor or public adjuster must also include your name so that they cannot cash the check without your approval. Seeking professional help is always wise, and certainly wise and prudent if needed with regard to a claim caused by a catastrophe. If you, for some unusual reason, reach an impasse with the insurer, document the dispute fully and in writing. Explain your position and why the insurance company's position is unreasonable. If the dispute does not require legal advice, you may be able to resolve it by calling your state Department of Insurance and speaking with their consumer protection people who are there to help at taxpayer expense. You can also get help if all else fails, by hiring a lawyer or a public adjuster. If the dispute does require legal advice, contact a lawyer who is experienced and specializes in representing policyholders. There are many consultants who claim to be insurance claims experts who do not have adequate training, skill, or experience. Before you retain one, investigate the person diligently by contacting licensing bodies and references. Make certain that you are aware of all deadlines included in the policy and in your state's laws. Make sure you know all the deadlines that may cut off your right to file a lawsuit. California, for example, has a 4-year statute of limitations for breaches of written contract, but most insurance policies require suit be filed with 1 or 2 years of the loss or the denial of a claim. If your claim is denied, seek legal advice immediately. In most states, the insurance company is required to tell you in writing that the claim is denied and that the limitations clock is running. That is, if you disagree with the insurer's conclusion to deny your claim, you have a limited time to hire an attorney to file suit. Make sure you understand all of the possible deadlines. Consult with the policyholder attorney as soon as possible. The time limitation can be as short as 1 year from the date of the loss and can be put on hold by actions of the insurer. If you wish to sue, or if you find it is necessary to sue, it is best to contact counsel as soon as possible before the expiration of the time limit. If you believe that your insurer is treating you unfairly, report all unfair claims handling to the Department of Insurance or your state's insurance regulator. The state insurance department tracks all policyholder complaints about their insurers and compiles the results. Most states have active consumer advocates in their insurance departments who will jump in to help you if they believe the insurer is not treating you fairly. In conclusion, many insurers involved in catastrophes provide their adjusters with policy limits authority and instruct the adjuster to be generous and resolve all catastrophe claims as quickly and reasonably as possible. If your house was one of those totally destroyed and coverage is available, there is a good possibility that you will receive the full policy limits immediately. If you did not carry sufficient insurance to totally rebuild your house and replace your contents, consider the acquisition of a factory-built home, which can be trucked to your site and completed with all appliances included for much less than a conventionally stick-built constructed home. Almost all claims in a catastrophe will be handled promptly and fairly. A person knowledgeable about insurance claims can better deal with an insurance company and save the expenses of a public adjuster or a lawyer. Don't take advantage of your insurer. Don't let an insurer take advantage of you. You are entitled to indemnity, that is, to put you back in the exact place you were before the loss, or actually, if you have replacement cost coverage, in a better place than you were before the loss, because all of your house's old components are going to be replaced with brand new components. You and your insurer should work together to make you whole. These 4 videos were adapted from my book, Zalma on Insurance Claims, and my book on mold claims, all published as paperbacks and Kindle books by Amazon.com. I now limit my practice to service as an insurance consultant, specializing in insurance coverage, insurance claims handling, insurance bad faith, and insurance fraud, and serve almost equally for counsel for insurers and policyholders as an expert witness and consultant. I also occasionally serve as an arbitrator or mediator for insurance-related disputes, and have practiced law in California for more than 44 years until I asked that my license be rendered inactive. And as an insurance coverage and claims handling person, I have more than 53 years in the insurance business. I was the first recipient of the first annual Claims Magazine ACE Legend Award, and I now publish at my blog, www.zalma.com/blog, daily insurance coverage claims materials, as well as multiple books published at Amazon.com. As the author of this series of 4 videos, I disclaim any liability, loss, or risk incurred as a consequence, directly or indirectly, of the use and application of any of the contents of this blog or video presentation. The information provided is not a substitute for the advice of competent insurance, legal, or other professionals. The information provided should not be relied on as legal advice. Legal advice cannot be given without full consideration of all information relating to an individual situation. If you found this video to be of use to you or to be worth passing on, please convey it to your colleagues and friends. It's free. And please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can be advised of future videos and future blog postings. Thank you for your attention.